Idaho College and today's broadcast of the North Idaho College Public Forum. The crew is comprised of North Idaho College television students. Your moderator is North Idaho College political scientist, Tony Stewart.
Good afternoon, ladies and gentlemen. Today we're going to start the first of three programs with you from the Department of Political Science at Washington State University. We're very fortunate to have, during that three-week period, two professors from that department that will discuss what we believe to be some very, very important constitutional and public policy issues. I would also like to take this opportunity to thank KUID on the campus of the University of Idaho for allowing us to use their studio during these broadcasts. Our guest today on program number one is Professor Walaford Peterson from Washington State University, as I indicated, the Department of Political Science, where he is a professor in the field of constitutional law. Dr. Peterson holds a baccalaureate, master's, and PhD degrees from the University of Minnesota. He has been a professor at Washington State University since 1968. Dr. Peterson, I, on behalf of our staff, want to express our appreciation for your coming and dealing with what we believe are very important issues.
Glad to be here.
Our issue today with Dr. Peterson will be a famous U.S. Supreme Court case for this area anyway, and that is the Chrisman versus Washington case that was an issue on the campus of Washington State University and dealt with the issue of search and seizures. Joining with me today in questioning Professor Peterson is a sophomore pre-law student at North Idaho College, Rich Cook. Rich, welcome to the program.
Thanks, Tony.
If I may, Dr. Peterson, I would like to commence the questioning with you. As I've indicated to our audience, we're going today deal with the question of unreasonable versus reasonable search and seizures and the right to privacy in one's home or apartment or dorm, whatever. And I think that in order for us to accomplish that goal, it's going to be important for you to take some time to discuss with our audience the issues behind or the background and some of the facts of the case of Chrisman versus Washington.
Okay, Tony, we begin on the Washington State University campus way back in 1978, which says something about the time these cases take, because we didn't get the decision on this case at the Supreme Court level until early this year. And at that time, back in 1978, a student, Carl Overand by name, was on his way actually to a party, and in his hand he was carrying a half-gallon of gin. Now, in the state of Washington, before you can wander around carrying gin, you have to be 21 years of age. A police officer who was arriving at the dormitory just by chance for another purpose saw Carl Overand and stopped him and said, "Are you 21?" Carl didn't answer the question, really. He said, "Well, I'll go up to my room in the dormitory and get my ID. And would you hold this bottle of gin while I do that?" And the officer said, "Well," he said, "I'll have to go with you." And so off the two went. It was a dormitory that is organized vertically rather than horizontally, so they had to go to the 11th floor. Now, this gave a friend of Carl Overand's time to run to the house phone in the lobby, call up to Carl Overand's roommate, Chrisman, and that's where the name of the case comes from now, Chrisman, and say, "The police have got Carl and they're coming up to the room." Chrisman got very nervous at that because in the room were a wide variety of things related to the use of drugs. Not only those things, but records about their purchase of those things from a, quote, glass head, unquote, shop down in Los Angeles, and checks and invoices related to their sale of these. Also, there was marijuana, and at least one small sample of LSD. So Chrisman was very, very worried, and he began trying to get rid of the material. In fact, he was going to throw it out the window, but he couldn't get the screen off. Back at the elevator, the police officer said to Carl Overand, "Oh, come on now, tell me how old you are." And Overand said, "I'm 19. Now that was a point at which the officer knew he had a minor in possession of alcoholic beverage. The officer didn't say to him, "You are under arrest." By the way, that really isn't necessary. But he did not at that point give him the Miranda warning that you have the right to remain silent, etc., that we hear on TV police shows so often. And that's a very important point in the case, because later it was to be argued that the officer should have given them the Miranda warning then. But at any rate, up they went in the elevator and down the hall. And here the stories differ. The police officer said he was walking right at Carl's elbow, but Carl says no, he was way behind. At any rate, Carl entered the room, and then it depends whose story you rely on. He went over to try to get his ID, and the officer, either a little bit later or immediately, was standing in the doorway leaning against the door frame. Now, from that point, he saw Chrisman, he the officer, and realized that Chrisman was quite nervous, and that made him a bit suspicious, apparently, and true to a good officer's training, I guess, he began looking around. And there, a little way away, about 8 to 10 feet, the record says, he saw what he thought was marijuana seeds and a little seashell pipe that he thought was likely to be used for smoking marijuana. And at that point, he entered the room to look more closely at the seeds to see if they were marijuana seeds. And when he saw them, he said, "Gentlemen, this changes things." And he then warned them that this was now a drug offense, and gave them the Miranda rights, told them that they had the right to remain silent, asked them some other questions, and they handed over some marijuana. When he saw that, he apparently began to realize that perhaps he had a big case on his hands here. People seemed to have a lot of paraphernalia around, and here was marijuana. So he called on his walkie-talkie. That becomes important because his walkie-talkie was operative. He could get in touch with other police officers. He called on his walkie-talkie. And another police officer came, his superior actually, and again advised the two students of their rights, and then told them that a full search of the room would be necessary, and they could either consent to the search or they could wait until the police department went to a judge and got a search order, which would take hours. Well, they consented to the search. And there was a great deal there, including written material with other people's names, addresses, and so on it. Well, they, of course, were then brought to the police station, and they were questioned there. At that point, they refused to answer questions. But you see, back in the room, they had been willing to answer some questions, and the questions they were willing to answer back there had given the police some leads and suggestions. Well, the county prosecutor, Ron Carpenter, Whitman County, decided to prosecute on the possession of the drugs.
But not in the case of the liquor or the gin.
Yes, not in the case of the liquor or the gin, that's right. In fact, that disappears now. So here what started as a liquor arrest, really, ends up as a prosecution for possession of drugs. Well, the defense attorneys for Overdahl and Chrisman made this objection. They said that Overdahl should have been given the Miranda warning about the alcohol arrest back at the elevator when the officer knew he was only 19. And they said that since he was not given that warning, everything thereafter was corrupted by that failure of police procedure.
May I interrupt to another point here? I think it's important for our viewers to know from you as an expert that they may be thinking, well, the dorm room of students would be different from a home or an apartment. And am I not correct that you have, under legal decisions that have been handed down, privacy in a dorm room as well as you do in other dwellings?
Yes, that's right. The dormitory room of a student is now protected the way a room in somebody's house is protected. That's something that developed in the last 20 years. So students have become people under the Constitution now. And so when the officer entered the room, he was entering a private place. Well, the students' attorneys argued then that all the later evidence should be excluded because of what's called the exclusionary rule, which means that if police proceed improperly, evidence they obtain is excluded. And of course, that's been a very controversial rule, but at any rate, it's accepted by the courts. And these arguments were made in Whitman County Court. And there, Judge Ferris made a ruling on them, and he ruled basically this, that while you might fault the officer for not giving the Miranda warning, that wasn't so fundamental a problem here that the evidence couldn't be used. And so he found against the students, the evidence was used, they were convicted. And they appealed. They lost in the Court of Appeals in Spokane, State Court of Appeals. Then Carl Overand dropped out and actually was put on probation for the marijuana offense. But Neil Chrisman appealed to the Washington State Supreme Court, and there Neil Chrisman won. The Washington State Supreme Court, with Justice Dolliver writing the opinion, said the officer had no power to enter the room. Ron Carpenter, the prosecutor for Whitman County, thought that this limited an officer's powers excessively. Talked with other prosecutors in the state, they agreed. And so he decided to appeal this one to the Supreme Court and went to the Supreme Court. Supreme Court took the decision. It was argued last November, and then, and I forget the exact date now, but January or February, it was handed down. And the Supreme Court decided in favor of the state of Washington and against Chrisman, saying that the officer could stay at an arrestee's elbow at all times to protect himself from perhaps the arrestee getting a gun, for example, or the arrestee destroying some kind of evidence. There were 3 dissents. Justice White, Brennan, and Marshall said no, and they had agreed basically with Justice Dolliver of the Washington State Supreme Court. So between the 2 Supreme Courts, you get a very badly divided group of judges. But the ruling was, and to put it down, I suppose, in just a little slogan, an officer can stay at the elbow of an arrestee even when the arrestee enters a private place on his own initiative. That is, the officer didn't say, you've got to go in there. The arrestee entered the private place on his own initiative. And so that's what the case was about. And it's interesting for, of course, people in this area, in part because it originated here, but in part because it is a clarification of the powers of an officer.
I have a few what I'd call cleanup operations on this case before I turn it over to Rich Cook to question you. For our viewers who might not be familiar, in Mount versus Ohio some years ago in the 1960s, when this question of protection of search and seizures and exclusionary rule was applied to states as well as it had been to federal agencies and federal courts. This particular case, Chrisman versus Washington, obviously from what you said, does not overrule Mount versus Ohio. It does not end the exclusionary rule. However, I am wondering if it has not what one might call weaken or qualify the exclusionary rule. I'm thinking particularly in your very fine description of the details that, for example, the fact that you would put someone under arrest or the possibility that they were going to be under arrest, and the court saying you can keep them elbow to elbow, but when he supposedly was arrested for another offense, gin, and he was not read his Miranda rights, one could ask, does that give the policeman even justification for moving on up into the 11th floor into his room, because that was the purpose that got him in the building in the first place?
Well, I think that one can argue that it is a shift in some measure of the MAP rule, although those rules are complicated. But one can argue it in part because, one, the Washington Supreme Court, Washington State Supreme Court that is, thought that the search had been illegal and therefore the evidence should be excluded. Further, a minority of the Supreme Court justices thought so. And the attorneys who argued the case for the students were willing to appeal it on the assumption that they were going to win. And so either one can say it is a slight weakening of the case, or one can say that it is a refinement for a very specific situation. Either of those two things can be said.
It's not a clean case, as you would say.
That's right. It's not a clean case. That is, it isn't a bright line case where you can say, well, that clearly is where the line should have been drawn. Life is complex.
Yes. In addition to the not reading the Miranda rights over the gin, he did pause in the door before he went in, which creates a question. Also, the fact that the students consented to allow the search the court has been clear, has it not? When you voluntarily allow searches, it's somewhat different than if you've objected.
Yes, if you volunteer that a policeman can search your room or your house, that is your decision, and the consequences of that are that the evidence can be used unless it can be shown that the police coerced you. For example, a policeman standing with a smoking gun in front of your door and says, "Can I come in and search?" You might be tempted to say yes. Of course, that wasn't the case here in any shape, manner, or form. But the issue of coercion does come up, and many people just assume they have to respond positively to a police question about can I search. A great many people do, and a great many young people do.
Rich Cut.
Dr. Peterson, as you pointed out, the Supreme Court varies in interpretations across the nation, and the federal Supreme Court, or United States Supreme Court, varies in its interpretation of the exclusionary rule also. I think an important point is the exclusionary rule actually needed to protect our constitutionally guaranteed rights?
Well, the exclusionary rule, we lived in this country without the exclusionary rule in a clear way at the federal level until 1914. Then it was added at the federal level by court decision as an understanding, a new understanding, if you want to put it that way, of the 14th Amendment. But the states didn't have to live by it until the case of Mapp versus Ohio in 1961. And we were a reasonably well-governed country up to that time. So the society can live without the exclusionary rule. But let's put it this way, there really is no reason why police can't operate in terms of legal practices that they can justify. And unless you have the exclusionary rule there, the police might take shortcuts, which would invade rights. And therefore, it's been argued successfully since 1961 that the police ought not to take shortcuts. They ought to live by the law too, and there is such a thing as privacy. Your house is supposed to be your castle, and people ought not to be able to walk in. So the exclusionary rule is very important and very useful, and I think it expands rights and privacy a great deal.
Chief Justice Berger has pointed out that what he calls the exclusionary rule a windfall to the criminals that results in the release of thousands of guilty criminals. Looking at it in this light, is there any way that, or are there any other viable alternatives to the exclusionary rule?
Well, some people have proposed that we live by the exclusionary rule, but we add one dimension to it, and that is the good faith exception. If the officer in good faith was trying to follow sound police procedures and made a mistake, then the mistake should not exclude the evidence. And that sounds like a compromise that a great many people in the society would accept. Many people who have had experience with certain police forces, and by the way, police forces vary, they would say, and I've heard it argued, that if you put in the good faith exception, you will train some policemen to say, "Oh, I was doing this right," and they simply will take shortcuts again, and it will be very difficult to prove that the officer wasn't acting in good faith, and people who have fear about certain police departments especially will say that will end effectively the exclusionary rule.
Dr. Peterson, I would like to continue on this because it seems to me that in the Fourth Amendment, and it's incorporated into the 14th, this whole question of unreasonable search and seizures is a very, very important part of the Constitution, and the Founding Fathers, or those who wrote the amendments, had a reason for putting that there. And as you've talked about the good faith doctrine just now, there is another doctrine that is coming to play in some of these cases, and that's the open sight doctrine. And I know in talking to you before that I think people sometimes misunderstand this particular aspect of search and seizures. When a policeman, even if he's legitimately in the home or the apartment or the dorm, or if he is not, and this comes into action, the open sight doctrine, I was very impressed that you've always indicated that the court has said open sight doctrine plus, that it's just not automatic that if there's something illegal on a coffee table or whatever, that it can be taken as evidence in trial. Would you elaborate upon that, please?
Yes. The notion here is that if a police officer is properly in a place and sees contraband goods, illegal goods of some sort, that then he has power to seize them, and that's the quick way to describe the open sight or plain sight doctrine. However, the Supreme Court, in a decision not long ago, Coolidge versus New Hampshire, wrote an opinion saying that the officer's open sight of contraband goods alone did not justify his seizure of those goods. It would justify his going to a court and getting a warrant to search. But it alone wouldn't justify it. There had to be other exigent circumstances. Of course, if an officer saw a person injured inside a house, he could enter that. But that would be exigent circumstances, a person injured. Or if someone were shouting help and the officer saw a scene of crime, he could enter then. That would be exigent circumstances. But in order to protect privacy, the Supreme Court in that New Hampshire case said that just plain sight alone doesn't justify an immediate seizure. It does justify going and getting a warrant. And why not go and get the warrant? Of course, there's a problem there. If somebody sees the officer see the contraband goods, then probably they'll disappear. But let me make an argument here. If we're going to have the rule of law and protect privacy, there is a price to pay. It is easier for people to enforce the law without living by rules than with living them. And so the price we have to weigh. Society has to weigh that. And the court is always doing that. And this case is one of the balances in that total weighing process.
I would like to point out to our viewers that Dr. Peterson has been kind enough to give me a table concerning the Berger Court cases of search incident lawful to arrest. And this is one of the most informative tables I've seen in a long time, Dr. Peterson. And from it, if one is a constitutional lawyer and attempting to take a case before the U.S. Supreme Court, and it dealt with such things as the open sight doctrine or reasonable search and seizures, if one is representing the defendant and contending that the evidence should be excluded, the chances are not very great. From what I note here, 6 to 7 of the justices, particularly 6 of the present justices on the court, tend to rule in relationship to the police and the prosecutor that the evidence has been obtained legally, or the qualifications are greater. Would you not agree with that concerning this table?
Yes, let me put it this way. We oftentimes use phrases like the plain sight doctrine or the exclusionary rule and think that they control judges. But judges interpret those phrases quite differently. On this table that Tony just mentioned, you'll find that in every search and seizure case there listed, Justice Brennan and Justice Marshall decided for the person and against the state. On the other side, Justice Rehnquist decided every time against the person and for the state. And in between are spread the other justices, and overwhelmingly they vote for the state and against the defendant. Well, that means, as you look across this, that you have justices who take phrases like exclusionary rule and plain sight and interpret them quite differently. And so, in a sense, when we say, well, what is the rule of law, we're making something of an error, because judges determine what that rule means in each case.
Rich Cook.
Yeah, based on the Washington versus Christmas case and many other cases that come up, would you say that the Supreme Court is trying to phase out the exclusionary rule and perhaps in favor of some other protection?
There's been much writing saying that the court is attempting to do that. And for practical purposes, reading the opinions of Justice Berger and Justice Rehnquist particularly, it looks as if they would like to modify the exclusionary rule in a substantial way. How would they modify it? I imagine that they would modify it by making the good faith exception to the rule. That's my guess. If they tried to overturn it, I think that Justice Stevens and Justice White and Justice Powell and perhaps Justice Blackmun would not go along with it. And certainly Justice Brennan and Justice Marshall would not go along with it. So it may be that the exclusionary rule will be modified. I think it will not be overturned, that's my guess, unless there are a series of new justices appointed. By the way, we haven't been talking much about Justice O'Connor here because she's so new to the court. She hasn't had a chance to decide on many cases. She did vote against the Chrisman argument in the Chrisman case.
We don't have a lot of time left, I think about a minute and a half. Dr. Peterson, I have to think of our viewers, and I know some are saying, well, what has happened to Mr. Chrisman and Mr. Overand that we've been talking about for 30 minutes, then you might bring them up to date.
Yes, well, that's one of those curious things. We oftentimes talk about Supreme Court cases in the abstract, and they're real people with the real pleasures and pains of all of us. Carl Overand served his probationary time, and then his record was expunged because Judge Ferris in Whitman County thought that he was a young man who had made a mistake, and he shouldn't live the rest of his life with that record. And as a result, Carl Overand was last August sworn into the United States Army as an officer and gentleman. And the last I wrote to him, he's down in one of the military forts in the South for the United States Army. I interviewed Carl Overand, and he said I was a different person than I am now. I interviewed him last August. He said, that's something I've put behind me, and I'm sorry that it happened, but I learned a whole lot from it. And he was seemed to me to be the kind of person who had learned something from this experience. Neil Chrisman is over in Hawaii, and I've written to him a few times and had very short answers back. I really can't say much about him, except this, that as far as I can tell now, he should be scheduled to come back, and he will have to either serve some time in the Whitman County Court or jail, or else be put on probation.
Thank you. I'm sorry we're out of time. It's been most informative, and we look forward to you being back next week. Ladies and gentlemen, our guest has been Dr. Professor Walliford Peterson from Washington State University, discussing constitutional law. He'll be with us again next week dealing with separation of church and state, and I want to thank Rich Cook for his questions. Please be with us then. Have a good week. I am Tony Stewart.
The North Idaho College Public Forum can be seen at this same time each week over this station. This production was videotaped earlier by a North Idaho College student crew for viewing at this more appropriate time.